All right, so we're going to go through the exclusive, what we call Form 130, exclusive right to buy buyer agency contracts. I'm just going to share my screen with a smaller group. If you guys have any questions, just interrupt me. You can throw it in the chat, but with a smaller group, a lot of times it's a little easier to just kind of have a conversation. Let me get everything on the row here. So hopefully what you're seeing up on your screen right now is the buyer agency agreement. Is that the case? Awesome. So we're nailing the technology so far today. That's all we can ask for. All right. So again, line by line, bear with me. And once we do these, by the way, go fill one out and send it to me and say, hey, did I mess up? What are some things to do? Again, it's a process. You're not going to know it all right away. This is why we do a contracts class every week. So appointment of the broker. So but this contract, basically the buyer goes in the first blank, appoints the broker in charge of, and then it would be Keller Williams Realty, Mount Pleasant, Keller Williams Realty, West Ashley, Holland Palms, whatever office that you're in, you want to specify that on there. Don't lose sleep if you accidentally put Keller Williams Realty. You get it signed and you're looking at it and you're saying, oh my gosh, what do I do? I need to change it. Being the broker of all of them, that helps a little bit. Again, this is basically kind of allows you to get an idea in your head of a description of what you're going to do. So what this says is the buyer appoints the broker in charge of Keller Williams as the buyer's exclusive agent, subject to the terms and conditions stated in this contract, which we'll go through. By appointing the broker as buyer's exclusive agent, the buyer agrees to conduct all negotiations for the types of property described in Section 2 below through the broker, and refer to the broker all inquiries made to the buyer about such properties from other brokers, salespersons, sellers, and others during the term of this contract. Negotiation, as used in this agreement, shall mean property shown, negotiated, or information requested by the buyer through the broker. Okay, so there's the technical stuff. Super exciting. What this means is, Mr. and Mrs. Buyer, we're going to get together. Right, I'm going to be your agent in this. Have been selected to be a part of Keller Williams and chosen to be a part of Keller Williams. I should put it that way. And what I'm going to do is work with you in negotiations. And what I ask from you, and we'll go into more detail, Mr. Buyer, later, if you want to walk through this way on what that means for you. But really, the big thing is that I'm going to be your main point of contact. Right. So if when you're out looking, please do. If you go to new construction, that's fine. Here's a stack of my cards. Just make sure that let them know that you're working for you, so that way you have representation from the beginning and there's no mix up in communication. I would prefer to be the first point of contact, Mr. Buyer. So if you're out and about and you see a for sale by owner, please shoot me the information. I'm happy to reach out to them, just so we can streamline all the communication, make sure you have all the information. All right, so part two, the purpose of the agency. So the buyer desires to purchase or lease real property. So if you do, by the way, work with anybody who's looking to rent, you would use this same document. Okay, and then you do some general description and some terms of what they're looking for. The reason this is kind of important in our market is if you've got a buyer, for instance, that is, they're checking out Myrtle Beach, they're checking out Charleston, they're checking out Hilton Head. You might want to be a little more specific in this area so they don't feel trapped in if they've got an agent that's helping them in Myrtle Beach, they've got an agent that helped them in Hilton Head. For the most part, though, you do want to get this kind of general. You don't want to open yourself up to the opportunity of being, quote unquote, pushed out of a transaction. Now, you don't want to force anyone to work with you should they not want to. But in this specific case, I don't know that I'd say, general description would be Mount Pleasant, 5 to 600, Carolina Park, new construction. You don't want to limit yourself to what this document legally says that you'd be involved in. All right, questions so far?
Yep.
All right, easy peasy. I like it. All right, broker's duties. So this is where we dive deeper into what our duties are in working with the buyers. And by the way, anytime where it says broker in any of these, with the exception of the release of contracts, you can sign as the broker. If you look actually at, are you seeing a new screen or is it just doing that tab?
It's showing the new tab.
Okay, good. All right, so if you look at, just as a quick side note, by the way, this is where I go as my default for forms if I just want to see them easily, is the SC Realtors. You log in here. Sean, if you haven't gotten this set up yet, you will. But what I'll point out here is actually give definitions in the purchase and sale agreement. And what it says here is brokers are licensed South Carolina brokers in charge, their associated real estate licensees, and their subagents. Quite frankly, this is obsolete because we don't have subagents in South Carolina anymore, but it states here as their associated real estate licensees. So when it says broker, that does include you as well. That doesn't mean that you don't have to come to me should you have questions or anything. It just, or that you shouldn't, it just does that. So anyway, our duties are to provide the buyer a meaningful explanation of agency. All right, so here's the deal. We should have already done that at this point. If I'm sitting down with the buyer agency agreement, I should have already gone through the description of the agency disclosure form and use the broker's professional real estate knowledge and skills to represent a buyer in a diligent effort and effective manner to locate a property which is available for purchase to the buyer. Okay, that's the first one. I'm going to work with you. I'm going to explain to you how agency works. I'm going to help you find a piece of property. Then, if I'm not representing the seller, I shall represent solely the interest of the buyer in all negotiations and transactions regarding the acquisition of the real property, and repudiate any agency or subagency relationships with the seller or the company representing the seller, and shall not claim the subagency compensation offered to the selling broker to multiple listing service. Quite frankly, the second half of that sentence is fairly obsolete, once again, because we don't have subagency. But basically what this is saying, as long as I am not representing the seller, I am not going to be taking on any sort of agency relationship or additional compensation from the seller than what is being offered in the MLS as their buyer's agent, as a buyer's agent, excuse me. If I do represent the seller as well as the buyer, i.e. disclose dual agency, the broker shall not disclose the buyer information obtained within the confidentiality. Now, the reason that I point this out in here is this is where you have the opportunity to say, hey, it's your choice should you want to go into dual or designated agency, right? But just understand is I am not able to disclose any of the confidential information that would adversely affect you in the negotiations. Now, again, that's a little bit of borderline saying things like, trust me, right? Like, so you don't want to harp on it too much, yet you do want to say, if you do have concerns, this is the part of the contract you can turn to and say, here's why you don't need to be as concerned, right? Nor should I disclose the seller information similarly obtained from the buyer without the consent of the party adversely affected of the disclosure. Okay, so I can't disclose anything that adversely affects unless you're saying, hey, you know what, go ahead and tell them. Right? You can always do that. The broker may represent other buyers who may be interested in the same property. Now, it's a good thing to know this because in this market, you might want to say in part of your consultation, just so you know, I also will be working with other buyers and there is a chance that they would be interested in the same property. Same things applies though. I don't disclose information that would adversely affect either one of you. I'm gonna consult you both to go in as strong as possible in that scenario. Upon the termination or completion of this agreement, broker shall keep confidential all information received during the course of this agreement, which is made confidential by written requests or instructions from the client, except as provided under South Carolina law. Basically, I'm going to keep everything confidential. If there's anything specific in this that you need me to make sure it was confidential, just let me know. All right, broker represents that broker is duly licensed under the laws of South Carolina as a real estate broker. Broker will use his best efforts as buyer's agent to locate the property of the type described in Section 2 and to negotiate acceptance of offer by the buyer to purchase or lease the property. During the term of this contract, the broker will give buyer information describing and identifying properties that appear to the broker's substantially meet the conditions set forth in Section 2. Basically, what that's saying is you told me what kind of property you want to see. I'm going to go help you find those properties. Now, a couple of things. And one thing too, just as if you, Latia, have you been on one of these before? I don't know. I can't remember if you have. It doesn't matter. I just
yes, a contracts call.
Yeah.
I like them.
So any of these is when I turn off the share and we get into the camera, like that means I got something really important to say, right? So this is like this special moment. Here's the deal. Everything that I just described gives you a resource to go to say, this is what everything means in the transaction. I don't know that you're going to go through and read through this to your buyer. But what you want to be able to do is skim through it and explain things. So a couple of things in here. Here's how compensation works. Here's how representation works. This says what I'm going to do in here. Mr. and Ms. Buyer, I am happy to go through this line by line with you. This is my Reader's Digest version. And again, I've got all day though. right? You don't want people, the biggest complaint, when complaints happen, one of the most consistent sub complaints of that is I was rushed through the documentation, right? And that's just, and that's why I do think it's really important in your buyer consultation to go through these things before they're putting in an offer, right? Because in this market, they got to move fast, right? They got to move fast. So just something for you to know on that. So again, it's good to know these really, really well, right? So you can describe them like a human being versus reading through this line by line. All right, so jump back on here. All right, the buyer's duties, right? We've talked about now what I'm going to do. Now let's talk about what you're going to do as a buyer. First of all, you're going to work exclusively with the broker and the licensees during the term of this agreement. Now, one thing to point out in here, if you do work on a team, or if somebody's working with you or going to help you or take over or anything like that, it's affiliated licensees, so it covers them in the agreement as well. Okay. By viewing any properties, previewing, et cetera, only with the broker or broker's designated representatives and not with another real estate broker, salesperson, or seller. Now, again, in the situation, Mr. and Mrs. Buyer, if you're out driving around, there's an open house, anything like that, here's a stack of my cards. If you want to jump in and take a look at it, just let them know you're working with an agent, give them my card, follow up with me. I'll follow up with them with any questions, right? You don't want to get into this area of limiting your buyer to go out, because let's be honest, the information of finding the actual property is not happening solely through you. So if you try to pigeonhole them into that, you just run the risk of them feeling like it's awkward. Trust me, I've done it. Second is exclusively allowing the broker salesperson to identify property, negotiate for buyer, and otherwise represent the buyer. Now, again, this is a little contradictory on that, which is why you'd have to say, I'm going to help you identify the property this way. Either however you're going to do it through your website or drip campaign, whatever it might be. However, that doesn't mean that you're not going to go out and obviously look on Zillow. And if you have any questions about that, let me know. If you don't have a resource, here's my app, go to my website. You want to guide them more to you, not because the information is necessarily better. I mean, it is, but you want to guide it more to you as that experience, right? So what I mean by that is, I know that you probably have a lot of apps that you use. If you want to use mine, the good news is on that is it only comes to me. Your information only comes to me. If you have any questions, if you see one that you like, you hit like, you inquire on it, I get the information right away, and you don't have to worry about people blowing up your phone. Okay. Referring the broker all inquiries received from any other form of real estate broker. So if that happens, if you are on Zillow because you've got your profile set up and you love Zillow, this is not the hill I'm going to die on, by the way, as a buyer's agent. If I've got a buyer who's looking to purchase a home and is ready to write an offer, I'm not going to say, well, before you do that, let's get you off Zillow on my website. Now, some people may disagree, right? I choose your battles. That ain't one of them. What you could say is, by being on Zillow, there's an opportunity if, you may get some follow-up from other agents, which is fine. We work together. It's called cooperation for a reason. Just let me know what any of those are so I can clarify any questions for you. Hold the broker harmless for liability as a result of incomplete and accurate information provided by the broker by buyer or seller. To broker by buyer or seller. This is always a fun one. This is one you probably won't spend a lot of time on. It says, well, if anything gets messed up, you won't hold me liable. They will, right? So just make sure that you're, explaining to them. These two, by the way, we have had a couple situations where buyers have asked them to be struck from the contract. Reach out to me first. But 9 times out of 10, I don't have a problem with that. These hold harmlesses that have automatically been put in here, our attorney's opinion is they're really not that super effective. If someone's going to blame you for something, they're going to blame you for something, right? Yeah. Holding this one especially, holding broker harmless as a result of seller's failure to provide a complete seller's property disclosure, and then indemnifying the broker against all claims, damage, losses, expenses, or liability arising from handling the earnest money. Sometimes we'll get pushback on those. Okay. The second part is assist the broker in the process of identifying negotiating contracts by providing them with reliable information, including financial information, right? How they're going to purchase, that broker deems necessary for the performance of this agreement, and making themselves available to meet with the broker and see the properties in order that the broker will be able to perform the promises. One of the things about this is, and just again, find a little bit better way to say it. This one's a little cold. Let's say, listen, when we go into this, because it's such a competitive market, sellers are really going to want any information we can give them to show what an awesome buyer you are, right? Not make sure you can afford it or anything like that. Just say we want a strong buyer. So when that happens, a lot of times we may need proof of funds if you're a cash buyer, proof of funds if you're putting a lot down. We want to have as strong commitment letter from your loan officer as possible. Again, set these expectations ahead of time. And then we talked about that, making yourself available to see the properties. Mr. and Mrs. Buyer, this is fast market, right? So if a property comes on the market, we may need to go to it quickly. If you aren't able to do that, let's come up with a game plan where we can work that out. Provide the broker and its affiliated licensees with this information: general nature, location requirements. We've already done that. They're obviously going to do it because they've done it up above. Authorize the attorneys and the settlement agent to furnish the broker copies of the final settlement statement prior to the closing date. This is one which is, this is an opportunity to bring up, hey, by the way, if you've never bought a house, you may not know how this works. You will actually have the opportunity to choose an attorney that will facilitate the closing. The seller may or may not choose to use the same attorney. We're starting to see them use separate attorneys quite a bit. That's completely up to you, right? Whether or not, who you want to use. Here's who I would recommend. But you can choose whomever, and they will be doing all the processing of the documents to make sure all the legal stuff of it that actually make sure you legally own the property the way that you want is handled properly. So that's what they will do in this. And this is just kind of telling you that. All right. Questions about that part so far?
Nope. I do like the fact that, because I'm also licensed in Georgia, so it's interesting out there how much different the exclusive buyer agency agreement looks,
right,
compared to Georgia's. Yeah. Plus, with like the little signature spots at the bottom of each page, so that you kind of do have to go through it more thoroughly than just signing the date at the top and then signing their name on page 4 or whatever it is.
Right. Yeah. Well, this one's pretty thorough. It's been a while since I was in Georgia, so I don't remember what that agreement was like. But yeah, this one's pretty good. They don't really change this one too much. The listing one they changed all the time. So anyway, squirrel. All right. So the brokerage fee. This is the one where it gets. I'm actually going to now completely negate what I just said, because this next section can be a little complicated. And this is how you get paid, basically. And that's what I would explain to them and say, all right, so here's how the compensation works. There are 2 main ways that happens. The first one, which is the one that most everyone uses, is what we call the brokerage fee. Okay. Now up here, I kind of skipped through this. Brokerage fees will be deemed earned when the buyer is under contract to purchase any property presented by the broker or negotiated by the buyer. This fee will be due and payable at closing or upon buyer's default. Something to know, not something that I would, come in guns a-blazing when I'm talking to a buyer. Basically says if the buyer defaults, the total compensation is due and payable, right? So if they come in and they decide they ain't buying the house, they could be liable for this. Now, again, I don't know if I'm going to sit down and say, Sean, now, if you don't buy, you're still paying me, right? Yeah. I don't know a lot of times where that's actually worked out pretty well. So 2 different types. There's the brokerage fee and then other. I love that. Brokerage fee, basically you get paid out of the transaction. Okay. The easiest one is option 2, where basically the brokerage fee is whatever payment the brokerage fee out of the transaction is. The broker shall be paid by the cooperating broker as stated in the multiple listing service, or as agreed to by the broker and cooperating broker, or as agreed to by the broker and the seller in a for sale by owner. Buyer shall not be responsible for paying the brokerage fee. Okay, so I start with that one because that's the most common one. It's basically like whatever, if I get hired, whatever that you, basically, Latia, you would say, whatever you negotiate to get paid, you get paid. Anything less, totally up to you, right? That's the most common one that's being used. Now we are starting to see a trend to option 1 under the brokerage fee, which has come about because there's been a compression of what's being offered out to the co-op. What this does is basically says the buyer shall pay a brokerage fee, which is the greater of either a dollar amount or a percentage. Normally it's the percentage one. So just for example purposes, let's say they put 3% in here, okay, of the purchase price of any property purchased or leased by the buyer, including for sale by owners. It also protects you, says if you do purchase the property, which the broker negotiated during the term of this, after expiration, let's say you negotiate it, and then you negotiated it, let's say on December 15th, and this expired on December 20th, you still would get paid as long as it closes within X number of days. So you want to put maybe 30, 45 days in here to give time for the expiration or for the contract to go through. Buyer will pay a broker the brokerage fee stated above. Now, so basically saying the buyer is responsible for this 3% up here. Then it says the broker shall use the best effort to obtain payment of the brokerage fee out of the transaction, but buyer shall have the obligation to pay the brokerage fee set forth in this contract. If the broker cannot obtain payment of such fee out of the transaction, the buyer will pay the difference. Any fees paid by the seller or seller's agent shall be credited against the brokerage fee. So basically what this is saying is if I put 3% in here and they're offering out 2% and I can't get them to pay any more, then you as the buyer will be responsible for that 1%. Okay, totally legal. Starting to see a lot of it happen. The one thing that this does bring up is we get a lot of listing agents who don't love when they get the phone call, and a lot of our agents make this phone call, and I think they should. You know, part of real estate is negotiating. Is if let's say I'm the buyer's agent, I'm out showing property, and I see Latia is offering out 2%. I call Latia and say, hey, just wanted to let you know I got a buyer's interested in your property. Right, we're going to schedule a showing. You're not going to show it if they don't negotiate it out. That's 100% can't do that. Before I move, before we show it or anything, I wanted to know if you or the seller are willing to pay more than the 2% that's offered, because the buyer has agreed to make up the difference on there. So this will cost them a little bit more money to purchase this house, and I just need to make sure we have all that information there. Is there any wiggle room or is anything in there? A lot of listing agents do not respond well to this. More and more are, and it's simply because they don't understand what you're doing. There's nothing wrong with making that phone call at all. There's nothing wrong with it unless you allude to the fact that you're not going to show the property if they're not paying you what you want, right? Yeah. And then neither one of you would do that. But if you ever get that call, it's either because of this or it's because they're calling to negotiate. I mean, we did it all the time before this option was in here. Well, I haven't worked with buyers in years, but my wife as a buyer's agent, and she would do it all the time. 2.5, she'd kind of let go. 2, she'd make a phone call.
Yeah.
Right. And that was before this option 1 was even in here. And a lot of times they would, be willing to pay a little bit more. If not, here's what happens. Then you have to decide, and your buyer has to decide whether or not it's worth buying that house, knowing that they will have an additional 1% in their transaction fees or closing fees. And you can always opt not to hold them to the 3%, right? I mean, a lot of times this can be used as a negotiation. If I've got 3% in here and they're looking at a $2 million house, if they're not going to come up from 2.5, I might be okay with it, right? Now again, if you're not, that's your choice for your business. I'm not saying that if you would hold to the 3%, it's 100% your choice, right? It's just what you decide on then. All right, questions about the brokerage fee? Cool.
No, but I love how you explain it. I love how you give us a softer way to explain it to our clients.
Right. Yeah, and it's in the beginning. Here's what will happen is in the beginning you'll probably use only option 2, right? Because right now you just want to work, or agents. So people in the beginning they'll do this, and then over time they may make the decision. Again, I use my wife as an example because she's far more experienced with buyers physically in the field right now than I am. She always uses option 2. And it hasn't been until recently where there have been a couple situations where she's kind of like, yeah, I could kind of see where this is maybe something I need to consider a little bit more. Again. All right. Now then there's the second part, other. Always fun. It's like miscellaneous. So there are 2 types of fees that you can also have your buyer pay. The first is a retainer fee, which basically says here, a retainer fee of, let's just say for round numbers, $1,000 is due and payable upon signing this contract. The fee shall or shall not be credited against the brokerage fee. Okay, so at this point, they would write a check. They could write it to Keller Williams. It does have to be paid to Keller Williams. It is a retainer fee. And then you can decide to say, hey, you're going to pay me $1,000, right? And then when you write a contract, when we close, I'm going to apply that to the commission that I make, right? Which I think is a smart move, right? Especially if you get a lot of out-of-town buyers that are searching. You're not a taxi service. You do have your time is worth something, so it could be something to take into consideration. I do think it would be if you are going to have it set up where you're not going to credit it against the brokerage fee. I don't know that I would call it a retainer fee then, right? Because most retainer fees are just that. They are used to retain you. They pay it, and then should you move forward to get any more money out of it, it can be credited to there. The reason is because it gives you this option right after it. You're basically at this point saying you're paying me more than what I'm going to get paid out of. Again, nothing wrong with it. I just think from a strategery side of it and negotiations, it's a little bit better to use the service fee. The service fee, however, is a confusing one because there are 1,800 different options here, right? So the service fee is the buyer shall pay broker for service, a service fee of $1,000 to be paid on blank calendar days, whether or not the buyer purchases the property, right? So if you wanted to treat it as a one you get right away, a service fee, you could say within 5 calendar days, whatever it may be. Then you have the option of the service fee shall be the only fee due to the broker from buyer under the terms of this contract. Well, a couple ways that happens is you can credit them, you can rebate them, the brokerage fee, you have a lot of options should you do it that way. Most people don't, right? Because they also want the brokerage fee. Then you have the option that it shall be credited to the brokerage fee described above and shall be kept by the broker. But hold on, sorry, I always get these mixed up. Okay, so this is saying it shall be credited against the brokerage fee above, and it will be kept by the broker whether or not the brokerage fee is earned, right? So again, it's non-refundable is what that says, but it will be credited against the brokerage fee. And then the last one says it will be credited against the brokerage fee described above and shall be kept by broker whether or not it closed. We said that, unless the buyer enters a purchase or sale agreement. In the event the buyer enters a purchase or sale agreement, buyer and broker agree that the above service fee will be credited against the brokerage fee in subsection A above, which again does say that it will be credited against it as long as they go to closing. The service fee is a confusing one. This isn't the best part of this contract, if I'm being honest. All right, questions about those? Okay.
Yeah.
Again, 95% of the time you're doing the brokerage fee, it's whether or not you want to ask for them to guarantee a certain amount. And whatever you decide is fine. It's totally up to you and your business. All right. Now let's go down to the terms. Go a little faster through these. Terms of the agreement shall start today and end on blank. As a side note, just as a pro tip, so to speak, I'd have your expiration on all your agency agreements be consistent. For example, your buyer agency agreement and your listing agreement, have them all end on either the end of June or the end of December. If you're not going to do 2 months out of the year and you're going to do it, they only wanted to be in 4 months. I'm going to do 4 months from now. Always round it to the end of the month at a minimum, just so you have consistency on the expiration. We moved with our team to moving the 2 times a year for listings. Like if you listed, it's either June, the end of June or end of December. So there's no mistake of anything going expired without us knowing, missing anything. We just always know on our calendar, huge red letters, check for expired listings on these only 2 days out of the year. If we ever got pushback, someone saying, well, I don't want it to go that long, I want it sooner, I'd put an easy out agreement in there. It says, in the event either party is unhappy in this situation, they can get out. Sounds better than that. I would do that. And you can also always change to make an exception for 1 or 2 people. It's like strategic, you've got high level of standards, which with what we call strategic flexibility. Okay, so now we've talked about the dual agency. So we've already talked about it before, but this is where they actually sign and acknowledge on this part right here. It says the buyer acknowledges receiving the explanation of the types of agency. Now, again, talk about validity. If you've not shown this to them and you're walking them through the contract and says, oh, wait, I haven't shown this to you. It's the small ticks along the way that can just don't let that happen. It's a very simple fix, right? Make sure you've already explained it to them. So you've explained that to them. And then they have the choice of whether or not permission to act as dual agent will not be considered, or permission to act as dual agent may be considered at the time I'm provided with the information about the other party of the transaction. And if I accept it, I will sign a dual agency agreement. And then the same thing applies with the designated agency side. So they basically say the same thing. So a couple things on this. Because of how we're structured in Charleston, if you do represent a buyer or a seller, and then the agent on the other side is a Keller Williams agent in Charleston, it is going to be designated agency, right? It doesn't matter it can be argued, since they're in different offices, that it doesn't need to be. I don't think that's a smart argument though, because it is the same broker in charge. 95% of the time in these situations, it will be designated agency and not dual, right? It just will, because the only time it would be dual is if you truly have, and I'll go back, we'll move to this, is if you're on a team, right? South Carolina law states if you are on a team and someone on your team represents, if let's say the two of you are on a team, Sean has the buyer, Latia has the seller, I'm the rainmaker of the team, then that would have to be dual agency. Well, I shouldn't have said me because I'm the broker. Let's say Latia is the rainmaker, Sean's an agent on the team, it has to be dual agent. Or if you're both members on the team, you have to be dual agent. If you are a seller, listing agent, and you have an unrepresented buyer, you don't have to go to dual agency, right? The buyer can choose to not be represented in that, which, quite frankly, if you didn't know them from Adam, I think is the better option. However, if they say, I really like you and I want you to represent me, then at that point, you can present it to your seller to see if they'll be willing to do so. The important part is how this is written. It says, I will consider it once I have the information about the other party to the transaction, right? So, I'm working with Latia as a buyer and would say, well, good news is you really, really like this house. It is, however, listed by me, and the seller is my husband or sister, whatever it may be. I, as a buyer, might have some reluctancy to say, I don't think you can be impartial in that. No judgment, right? But at least they have the option at that time to make that decision. Okay, so that's the important part. All right, other potential buyers. This is where we formally disclose again. We talked a little bit about it earlier, but this is that the buyer understands that there are other potential buyers who have entered in a similar agency, and we'll look at similar properties. Buyer consents to broker's representation of such other buyers. Broker agrees not to give buyers confidential information to such buyers and not to give such other buyers confidential information about this broker. The indemnification of the broker. Broker promises to disclose to the buyer whether or not to the broker whether or not they have signed an agency agreement. Don't have to go through all of this, but basically it's saying, Mr. Buyer, by signing this, you've been forthcoming. You are not in an agency relationship with another agent. Is that true? Because this is what this says that you are not. If they are and they don't want to work with them anymore, reach out to me. But the first thing that you want to say is, well, until you are no longer, I can't represent you as long as you're represented by them. And they say, well, how do I get out of it? And you say, well, you just call them and cancel it. Don't say that, right? You say, I can tell you how you would get out of one of mine. I can't speak to their agreement and legally wouldn't be able to. However, so if you just contact them, ask them what the process would be to get out of the contract if they have one. And then if it gets one of those where it's awkward and they don't want to, or the agent pushes back, reach out to me and we'll figure it out. We don't have a lot of these happen that we don't figure out. There's usually a reason the buyer doesn't want to work with the buyer's agent, and that buyer's agent probably doesn't want to work with the buyer anymore anyway. Section 10 does give the option as to whether or not they have the buyer's permission to disclose their identity to all the property owners and third parties, right? So again, you need to let them know, hey, this is saying when you submit an offer, your name's going to be on the contract. If you don't want your name to be on the contract, then we need to come up with a second option. This rarely happens. I see this happen a couple times a year. Typically, it's with the two situations that happen. One is a high net worth individual, or like a public figure, and then second would be like neighborhoods. I want to purchase in the neighborhood. They know I live in there. They know my financial status. I don't want them to use that against me, kind of thing. Now, they can't not disclose their identity because they're hiding some sort of material fact. However, that's typically not the case. All right, so this is the one that we also get pushback on sometimes, which is the broker liability limitation. What this is saying is the buyer agrees to provide broker will provide the buyer with benefits, services, assistance, and the value of bringing this contract. In consideration and recognition of the risk, rewards, compensation, and benefits arising from this transaction to the broker, buyer agrees that he shall not He shall pay the broker's attorney's fees, and the broker and the broker shall not be liable to the buyer in the amount exceeding the broker's compensation by any reason or act of omission, including negligence, misrepresentation, errors and omissions, breach of an undertaking, blah, a lot of scary stuff, blah, 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 blah. What this basically says, and then it says buyer will hold harmless and pay attorney fees for the broker from breach of contract. Most buyers, especially if you get some higher end buyers, when they read that, they're like, not a chance. Am I going to sign something that says that if you omit information and something goes wrong, that you're only liable to the amount of what your commission would have been, right? I get it. If you've got a buyer that pushes back on this, basically two parts to how you explain this. What this says is I'm limited in my liability in this transaction. So if something goes wrong in the transaction and you get damaged and it goes to court, this basically states that I'll be held harmless from it and that my involvement in it, I can't be sued for more than what my commission would have been. I do want to explain to them what I mean. If they go back and be like, that's not happening, like if you mess up and it causes me, you're going to make 10 grand and it causes me $30,000 worth of damages, I want you to pay for all of it. If that happens, reach out to me before you agree, but 9 times out of 10, this is one we've had our attorney look at. He's like, look, if you have that in there, it doesn't matter, right? If you have this hold harmless in there, they're going to sue you for more anyway. This doesn't protect you as much as you think it does. And to push back on that would probably damage the relationship more than it would benefit, your long-term liability. And oh, by the way, as an agent, don't mess up, right? So, and it won't be an issue. Now, again, there's also actually messing up and perception of messing up. So we do have to deal with that. All right. The next paragraph does need to be updated, but you can describe it this way because it is the non-discrimination paragraph, which basically says how I change this now is just say what this is saying is that the broker and buyer agree that all actions carried out under this contract should be in full compliance with state, local, federal housing laws against discrimination on the basis of the fair housing laws is what I would say. The reason I'd say that is because where it is now, there are new protected classes that are not in here. You can go through it, but at the end of the day, it's like, listen, this is, unfortunately, we may have to say this, or unfortunately, we have to say this, but I just want to be clear that working together, we're not going to be discriminating on any of the protected classes. Professional counsel. This is one that I encourage buyers to actually highlight this paragraph, or excuse me, encourage agents to highlight this paragraph, because here's what happens is, and here's what I would say. Okay, Latia, one thing I want to talk to you about a little bit is this professional counsel paragraph. And when you work with me, I'm being retained solely as a real estate agent, right? Now, what I'll do is help connect you to all the other professionals, because if you're new to the area, you may not have them. And I have recommendations. You're welcome to use who you are. But what this says, and this kind of tells you here, is that I am not an attorney, a tax advisor, or a lender, or any of those. And that's why we're going to bring those people in. So where I will help facilitate those conversations, I don't want to be the only point of contact for those conversations, because I want to make sure you hear it from the professional. All right. So there will be a lot of people that you talk to in this, and I'll be part of those conversations. And I just want to say, this is why, right? Because I want you to know that you want to seek that professional advice, because I'm here from the real estate side of things. Now, that 30-second script that I just did can be a game changer for you when it comes to when something goes awry. Because what tends to happen, and I get it, we've got an average sales price of almost $400,000 in the area right now. I mean, you're looking at a $12,000 paycheck. I mean, it's a lot, and you want to be you want to be involved. You want to make sure you're providing that service, and I get it. What tends to happen though is if you become the hub of communication for the buyer from the dozens of people outside the hub, the moment something gets lost in translation, it comes solely down to you, right? And so in those, it's going to be, I'll just use the home inspector as the biggest one, because this is where I see this a lot, is we try to be professionals that say, listen, I'm going to be there for you, and I'm going to help translate some things with the home inspector, but all questions regarding that, we're going to make sure that you talk specifically to them, right? And then you just enter, and I know that sounds simplistic, but we tend to feel like if we're doing that, we're having them do more work. Not if you tell them ahead of time while you're doing it. They want to hear it from them, right? So again, it will save you. I can't tell you how many times where we've had a broker issue come in where, come in and I end up talking to the client, and they're like, have the questions. We put them in touch with the right person there, and they would say, Joseph, if so-and-so if we had just had that communication directly with so-and-so in the beginning, there would have been a lot of this would have been cleared up, right? Especially happens when it comes to repairs, what repairs should be done, that sort of thing. Like, again, let the professionals talk about it. Okay. Mediation clause. Last couple of paragraphs here. Mediation clause basically states that in the event, use the wrong one here. Basically says in the event that you and I have a dispute or claim arising out of this agreement, we will go through a mediation process before suing each other, right? And the National Association of Realtors will facilitate that. We'll use the South Carolina Association of Realtors. They have actually mediators that don't charge, which is great. I'll be honest with you, I don't know any time. I mean, I can't even remember the last time in a buyer agency situation that it came down to a mediation because of some sort of dispute between the buyer and the agent. It typically comes down to the buyer and the seller, the agents, whatever it may be. It's rarely, that it needs to be mediated. The only time that something happens is if something goes wrong with the transaction, right? There's very rarely the times of this where we say, no, I'm going to hold you to paying me, or no, I'm going to refuse to, say you can't get paid. Paragraph 15 basically states, South Carolina law does say that I'm not responsible for obtaining and disclosing information on the South Carolina Sex Offender Registry. I love them, and therefore you can't sue me if you don't figure this out, is what the next line says. So if you do have any questions of those, you definitely need to go and look those up. I'm just not able to provide that to you. 16 basically says this is a written instrument. Let's see. It can be changed only in a subsequently written instrument by the signed parties. So again, we're agreeing to everything in here. It's an agreement. If we do want to change anything in it, we do have, after signing it, we have to agree to that in writing. Section 17, any contingencies you would have. This is, the only thing I really see in here. Some people may ask to specifically state, in the event a property is purchased in Myrtle Beach, this contract becomes null and void or something like that. Or if you wanted to put an easy out, all parties agree that if anybody wants to terminate, any party can terminate this agreement at any time with, written notice, email notice. I would, Section 18 says that you can use fax machines as well as electronic means. It is the proper way to deliver these. You can use online signatures, and just says this is the proper way to doing it. Surveillance, buyers advise that properties they enter may have both audio and video surveillance. And we advise the buyer to be aware of possible surveillance and conduct any and all communications about the potential properties offsite. So if we are going to talk about them, let's make sure we go back to the car, go to Starbucks, whatever it is, but let's not talk about it on the front porch in front of the Ring doorbell where you're either going to show your cards or you're going to aggravate the seller because you said you didn't like the fuchsia carpet, right? So you just want to make sure anything you talk about is out there. And then once again, it says this is a legally binding agreement and the buyer shall seek further assistance if the contents are not understood. Basically meaning go talk to an attorney if you have any questions about this. I've kind of explained to you my knowledge out of this. Buyer and broker acknowledge receipt of a copy of this agreement and copy of the South Carolina Disclosure of Real Estate Brokerage Relationships form. And that the buyer agrees to receive communications from the broker at the email address, phone, and fax number listed below. And you're done. So there you go. In 49 minutes, we went through the buyer agency agreement. What questions do you have? Either specifically on the buyer process, that agreement, anything at all?
Most of it was straightforward. Just the differences between like the designated agency and dual agency was something I had a question about.
Okay.
Because that's something in Georgia, we don't do dual agency. So that was the one thing I needed to figure out exactly what that was. Because over here, it's just, we're not allowed to do it no matter what.
Well, I mean, with your permission, we can kind of go through that fairly quickly now. I mean, we've got a little bit of time. Okay. Latia, while I'm pulling this up, anything that you have?
I'm good to go. The more I see it, the more comfortable I am with it. So, yeah, I'm good to go. I would eventually have a question about how do you work with clients who are leasing, how the form is written and the process for that. I'm not there yet. but
Right.
I'm glad to know that that form is the same form. And like I said, the more I see it, the more comfortable I am.
Yeah. Yeah. It's the same form. We don't have a huge rental market here for people to show. Now, I will say we have a lot of agents locally that have embraced helping corporate leasing clients. We've had a couple people who've gotten in with, help. Boeing has had a program that they'll pay for the lease, and honestly, if those people stay and you stayed in touch with them, they become buyers. We've got an agent in our West Ashley office, Tara, who did a lot with Mercedes-Benz and did a lot of rentals, and her business is crushing it right now because she stayed in touch with them, right? And
That's
she just treated them
awesome.
like, yeah. Proceed cautiously though in pursuing that, right? Because that is a lot of work, right? And it is not, and a lot of times it's not a lot of pay.
I've tried doing rental stuff, and I don't know exactly how it is out there, but everything that pops up on the MLS as rentals here, I'll call the agent, because after driving to show 1,000 of them, I've now called the agent to ask, do you guys have any pending applications? And they go, oh yeah, there's 10. And I'm like, okay, so we're not even going to go look at this.
Gotcha. Okay.
It's good practice.
Oh, that's good to know.
Yeah, but I've tried for 2 years with probably 10 different people trying to do rentals and just haven't had luck. So I'm unfortunately just getting over that, because I've got some clients that were trying to buy but needed to be in before school started, so they wanted me to help them rent, and I didn't want to lose that potential purchase. But
okay,
rentals that had a bunch of people in them, so there was.
That's good to think about, is that why put your bid in if there's already 20 people ahead of you? Right. Let's keep moving.
Right.
All right. Well, thank you.
That application fee of like $50, and then just get turned down, and they don't want to spend, a few $100 getting denied properties because all of them already have people.
Right. Right. Yep. Okay. Well, hey, I appreciate this call.
Right. Well, good. Well, here's what I'll do really quickly. I'll do a quick designated versus dual. I won't go through the whole thing, but I'll just kind of go through, I'll skim and then go on the highlights. And then if you want to, we may put it on actually as one of the, we've got 2 weeks this month that I can have extra wildcard stuff. So basically what the whole thing tells you is you have two choices. You're either a customer of the firm or you are a client of the firm. Okay. If you're a customer of the firm, it's what we call transaction brokerage. And just so you know, it is the default status in South Carolina. So if they are unrepresented in a transaction, they become a customer of the brokerage firm that is represented or that is part of the transaction. Okay. So it doesn't mean anything other than they're just a customer in there, but it does default to that. So if if someone comes in and they don't have an agent, they're treated, it's transaction brokerage, right? I mean, that's basically what it is. Now, should they want to become a client of the firm, there's two ways. Obviously, the seller does it by signing a formal listing agreement with the firm. The buyer does it by signing a buyer agency agreement. Now, again, we'll use the situation of a sign call because it's the easiest one. So Sean has a listing, a buyer comes in not represented. Do you have an agent? No, we're not sure, that sort of thing. Okay, I do need to go over the agency disclosure with you. You might want to, it's at first substantial contact, right? So it's not, if they call and they're asking some information, give them the information. Should they want to move forward, then I would say, I just need to go over this with you. Tread lightly, right? You want to be careful. Latia calls me and she just wants some information. And I try to explain this to her. She's like, listen, I just want some information on the property. I don't even know if I'm interested in it. And then if she wants to come see, I will ask, are you working with an agent? And then if she wants to come see it, when she comes to see it is when I would go over this with her. I might send it to her ahead of time and just say, hey, by law, this is a disclosure agreement. Don't have to sign anything on it. I just want to make sure that I've shown it to you. And then you can send it to them ahead of time. And you go through and they're basically the two types of agency that we have. It's listed as 4, but really the agreed upon are only come down to, I guess I should say 3. Single agency, I actually said that wrong. There's really 2 and then with 2 subparts. But anyway, there's single agency, which we only represent one client in there. Dual agency exists when the real estate brokerage firm has 2 clients under one transaction, a seller client and a buyer client. Okay. that plays out in 2 ways. You have disclosed dual agency. In disclosed dual agency, the brokerage firm representation duties are limited because the buyer and seller have recognized conflicts of interest. Both clients' interests are represented by the brokerage firm. As a disclosed dual agent, the brokerage firm and its associated licensees cannot advocate on behalf of one client over the other and cannot disclose confidential client information concerning the price negotiation terms or factors motivating the buyer client to buy or the seller client to sell. Each dual agency agreement contains the names of both seller clients and buyer clients and identifies the property. Now, again, this is the general description. However, when you go into the actual agency agreement, it specifically says in there, the broker, if you're representing both, yes, it may be limited, but I cannot disclose information that doesn't change that will adversely affect you. Okay. Again, the only time there'd really be dual agency is if they truly wanted to be represented by both of you. You were on a team, or you had a buyer on a listing that I happen to have, which it would be Lynn. So one could argue it wouldn't be dual agency, it'd be designated. We would do dual just because we want full disclosure. You can check the stats. I don't have any listings out there anyway. It's not really going to be happening. Then you have designated agency. In a designated agency, a broker in charge may designate individual associates to act solely on behalf of each client, which is typically what happens because let's just take the extreme example. We've got, agent in Isle of Palms office and agent in the Somerville office. They're designated in this transaction by being part of Keller Williams, right? It's not like I picked this transaction and then I went and picked, Tom and Sue. The broker in charge designates the individual licensees to act solely on behalf of each client. Designated agents are not limited by the brokerage firm's agency relationship with the other client, but instead have a duty to promote the best interest of their clients, including negotiating a price. The broker in charge remains a disclosed dual agent for both clients and ensures the assigned agents fulfill their duties to their respective clients. At the time you sign an agency agreement, you may be asked to acknowledge whether or not you would consider giving written, again, consider is the big one, consider giving written consent, allowing the brokerage firm to designate a representative for you and for one of the other client in the designated agency. Each designated agent agreement contains the names of both buyer and sellers. The buyer's clients identified the property. They have a choice to do it from there. So going back to the situation of you've got a sign call, if that person says, hey, I want to be represented, but I'm not comfortable with dual agency, you can pick an agent in the office to say, hey, will you represent them in this? And that doesn't necessarily mean that you have to split your commission completely evenly with them. You could come up with an agreement that says, listen, I'm literally handing you this client, and here's what I'll pay you on that. That's up to you. I'm not advocating one way or the other on what you should do. I've done both. When I first started, I was taught, you pay that agent a referral fee versus the co-op. I now know that there's a lot of value in the fact of just having them represent. I was preparing for this anyway, so it's up to you on that one. So that's kind of in a nutshell. I think what I might do, Sean, is because we can never talk about this enough, is on the next one. What's today? Next week is the purchase and sale. I might throw this in instead of the purchase and sale next week. I think people get a lot of that, but we'll get it on the calendar here soon to cover those specifically some more.
Perfect.
All right. Anything else?
No.
Awesome. Well, as soon as we hang up, of course, both of you will think of a question, and that's totally normal. So if you do, either shoot me an email, give me a call, and we'll get it worked out.
Perfect. And then you said we can fill out a mock one and send to you also as needed?
Yeah, feel free to. Yeah, no problem.
I meant to do that. I actually somehow did a crash landing and have a buyer under contract over there right now.
Nice.
And it was before I had taken any of the classes. I was just kind of putting feelers out and had to watch a YouTube video on how to fill it out. So I've got Dave's closing. I've got him helping out the transaction part because, I have no clue exactly what your market center is looking for. And I told him, read through everything and make sure there's no errors because I'm not having compliance mad at me for my first transaction. And
listen,
although I'm sure there still is stuff, but now
there will be, and the reason we have compliance is to protect you guys. It's not to test who the smartest is, right? It's like if you've got compliance errors, that's why we have compliance to say, hey, here's an error, fix it. That's why everything should be turned in earlier so it doesn't become an issue. But yeah, don't worry about getting on anybody's bad side. That's not possible, especially if many compliance errors. Shoot, I have compliance errors when I have, if I were to have a transaction or two here and there, I'd probably have an error. So no problem at all. All right, guys.
Cool. Thank you so much.
Absolutely. Let me know if you need anything else. Otherwise, have a great day.
Will do. You too. Thank you.